Hello, my name is Kevin Staker. I'm an estate planning attorney in Camarillo, California, and let's talk about living trusts. There are three ways to plan your estate. What do you think is the most popular way to plan your estate? Well, if you answered nothing, you're right. Most people have done nothing. Let's talk about what happens if you do nothing in your estate plan. The problem is if you own your own home where you have over $150,000 in assets in your name alone without a beneficiary, that is going to trigger a probate court proceeding. On that, what that is, all that is just a court proceeding where the judge gives the power to someone to take control of your assets and to transfer your assets to the beneficiaries of your estate. That's all a probate really is. And on that probate court proceeding, it's a very expensive court proceeding, especially here in California. The really difficult thing about a probate is that the attorney's fees in the probate are based on the value of your estate. And so for your average probate of a home here in California, we see those fees in that probate are around $13,000. That's a lot of money to be lost that won't be going to your family and friends. The other problem with doing nothing is that the law will decide who will get your assets, and you may not like what the law decides as far as who will get your assets. And also finally, in that probate, the judge will decide who will be the executor of your estate. So that that's the problem with doing nothing is the expense and the delay and the lack of control you have over everything. Now, estate plan number two is to have a will. And yes, it's true, with the will you do have the advantage in that you will decide who will get what of your assets, and you will decide who will be the executor of your estate. But the problem is it is just as bad as doing nothing. A will is a ticket to probate. You may have a beautifully drawn will that describes in detail all of your assets, who your beneficiaries are, so that any sensible person can be sure to whom your assets will go. But the problem is, it's still the court has to be involved, the judge has to be involved, because the judge has to change title on your assets, has to sign the order changing the title of your assets from your name into the name of your executor, who then can distribute the assets out. So that's the problem with estate plan number two. Estate plan number three is to do a living trust. So what is a living trust? Well, a living trust is a document that you sign that takes the place of what you think of as your will. And you'll name yourself as the trustee of your trust. And so you will still control everything absolutely. You'll continue to file your same income tax returns as before. Your property taxes won't change. But the key is that you'll change the title on your non-retirement assets into your name as trustee. So for example, if you own your home and other real estate, you'll sign a deed for each piece of real estate to transfer it out of your name into your name as the trustee of your trust. And so the beauty of this is that if something happens to you, the title to your real estate and these other assets in the name of the trust avoid a probate if you passed away, because your assets are already in the name of the trust. They're out of your name in one sense. They're still in your name during your lifetime, but when you're gone, they are in the name of the trust when you're gone. And so it's a very simple thing for your successor trustee, for example, on your home, to record a copy of your death certificate with a county recorder, and so your successor trustee can take over without having to go to probate court. The other advantages, of course, of living trust are you get to decide who gets what of your assets, and so the law deciding, and you get to decide who's going to be your successor trustee instead of a judge deciding. Another major advantage of living trust is to avoid a court conservatorship. It's a little known fact that if you become incapacitated, your family can't sign things for you unless you sign the proper documentation giving them that power. You may be married, You may be incapacitated because of a stroke or something like that, and your spouse, your family members, they cannot sign on your behalf. And so your family has to go into court to ask someone to be appointed by the judge. It's actually the same probate judge, to be your conservator. And the problem with the conservatorship is it's like a probate. It's very expensive. The paperwork is downright obscene that has to be submitted to the court just to make your family member or friend, whoever it is, to be your court conservator. And every year, and then periodically after that, your court-appointed conservator has to report to the court regarding every penny they spent on your behalf, which is a wasted, useless exercise because there's no way your family member can prepare that. It's called a court accounting on their own. It's just way beyond their ability. They're going to have to hire me or some other attorney to prepare that paperwork. So setting up the conservatorship and also the assistance they'll need every year will cost thousands and thousands of dollars. It's a real tragedy if a conservatorship happens because it's so easy to avoid if you sign a living if you have a living trust and the other documents that go along with it. Now, another advantage of having a living trust is it's very private. See, a probate court proceeding is a public proceeding. Any one of us could go on down to the probate court tomorrow and ask to see any of the probate court case files and find out all sorts of things about the poor person who has passed away without a living trust, whose estate is being probated. You can find out, you actually can find a list of all their assets. You'll see the names and the addresses of all their family members. It's a very public, intrusive proceeding. A living trust on hand is very private. Only you, your family members, your other beneficiaries, and your attorney will know who is receiving your trust assets and what your assets are. Another advantage of living trust is that it takes a lot less time to wrap up your estate after you're gone. You see, in a probate court proceeding, it takes a very minimum, if you cut it to the shortest, of 7 months from start to finish for a probate. Where with a living trust, everything can be distributed out of your living trust as soon as your family receives your death certificate. So everything can be distributed out usually the next week after you're gone. So that's a tremendous advantage of living trust is your assets can be distributed out much more quickly out of your living trust. Now, another advantage of a living trust is, actually, if you could, let's to talk about the downsides of a living trust. To everything, there's a pro and there is a con, and there is one downside to living trust, and that is it costs money. We charge a fee to do this, and so just call up our office and find out what the fees are. I think our fees are pretty reasonable. We get a lot of clients, and it's an honor for us to assist people to get their living trust done. So it does cost money, but it's like the Fram oil filter commercial. For those of you who are baby boomers and can remember that commercial, you either pay me a little bit now, or your family will pay me a lot later on in that probate and possibly conservatorship. Now, another advantage of a living trust is for a couple. The reason why is nearly all couples who do not have a living trust hold title to their home as joint tenants. And the problem with joint tenancy, to make a long story short, is that at the death of the first spouse, only half the capital gain is eliminated at the death of the first spouse. In other words, if one spouse dies and the surviving spouse goes to sell the home, they're going to have some capital gain that they're going to have to deal with in some way if they go to sell that home soon after the death of that first spouse, or even years down the road, have some unnecessary capital gain to deal with. It's unnecessary because if a couple does a living trust, almost always they will make their home titled in the living trust as community property. And it's a strange thing under the interplay of the joint tenancy law and tax law. Joint tenancy is not community property under the tax law. And so instead, if a couple holds title to their home and other real estate, matter of fact, any capital asset, a stock bond, a mutual fund, in community property, at the death of the first spouse, all the capital gain is eliminated. The technical thing is that there is a step up in the income tax basis to the fair market value of that asset. So when you pass away, if you're a couple, your home will get an increase in its income tax basis to whatever the value is as of the death of that first spouse to pass away. And so the surviving spouse can sell the home at that point, doesn't have to pay any capital gains. Or if they hang on to it a number of years, that home can go up under the present law another $250,000 from that value as of the date of death of that first spouse to die, and the surviving spouse doesn't have to pay any income taxes. That's a tremendous advantage for a couple in doing a living trust. Another advantage applies to both couples whose assets are over the estate tax exemption. Now, that estate tax exemption it is actually indexed to inflation, so it's over $5 million. It's been adjusted for inflation since the year 2010. So for a couple with assets over $5 million, and also couples where there are children from a prior marriage, there's another important advantage to the living trust, and that is that couple can do a living trust where at the death of the first spouse, that trust is split into two trusts. And so into one trust, let's assume everything is community property between the couple. So into one trust goes the half of the trust assets of the deceased spouse. There's a second trust that is formed that receives the one half of the assets of the surviving spouse. And the great advantage of this type of a split trust system, now this doesn't happen until the first spouse passes away. The great advantage of this is on that half of the assets of the deceased spouse, they're held in this trust. This trust is actually an irrevocable trust. So that has the advantage that if they're children from a prior marriage, the surviving spouse cannot change the fact that those assets of the deceased spouse are going to go out to the people that they want them to go to. Typically, it's to their own children. The other advantage of this, and for a couple with assets over $5 million, the advantage of this is that this irrevocable trust escapes estate taxes at the death of the surviving spouse. No matter what those assets have grown from, if they may have grown from over $5 million to $50 million at the death of the surviving spouse, and those assets will escape estate taxes. That is a great advantage of living trust is for a couple with over $5 million assets, or a couple where they have children from a prior marriage that they want to protect. The other documents that go along with living trust are number one, you still need a will. It's interesting. People are surprised by this because the trust takes the place of what you think of as your will. It has the who gets what part in, but you still need a will. It's called a pour-over will, P-O-U-R, because it pours over into the trust any odds and ends are outside the trust. Typically, your automobiles, your basic checking account are outside your trust. Your pour-over will pours those over into the trust after you're gone. You have to be careful, though, to make sure that those assets don't total over $150,000 when you're gone, because that will trigger probate. So if you have $150,000 in assets in your name alone without a beneficiary, that will trigger probate. Cars don't count towards that, though. You can have a $400,000 Rolls Royce in your name alone, and will not trigger a probate on its own. On this, as far as your retirement plan assets, those are usually those are actually separate from the trust. You do not change the title of those to the trust, and everyone's different as far as who the beneficiary will be. Usually, for a couple, you'll normally leave Your surviving spouse is the beneficiary. Depending on the age of your children, you might leave your children as the backup beneficiaries. You see, your spouse can do a tax-free rollover, a trust cannot. But on the other hand, if your children are young, it is really important to have your spouse as the primary beneficiary and to have the trust as the backup beneficiary. That way, your successor trustee can control as far as the distribution of assets out of your trust. Number two, you also need a financial power of attorney. If you become incapacitated, the trust can't control things like your IRA, 401k plan, health insurance, your basic checking accounts, usually outside of your trust, your cars. So if you become incapacitated, the power of attorney gives to the person you've named the power to handle all these financial issues outside of your trust. The number three, we also prepare for an advanced healthcare directive. In this, you will name someone to have the power to make healthcare decisions for you, including the power to take you off life support if you're just going to be a vegetable on life support. All those documents, the trust, the will, the financial power of attorney, the advanced healthcare directive, also the deed to your home, those are all included in our basic fee for doing a living trust and the other estate planning for you. We'd be honored to assist you. We offer free initial consultation. So just give us a call at 805-482-2282. We would be honored to meet with you. It's a meeting where where there's no pressure. We're just honored to talk about your estate planning, and you'll decide whether or not you want to go forward. So I hope to see you soon. Thank you very much.